tell me, it was tough for me reading from the briefs, exactly what behavior Article 5, Section 14 either prohibits or requires from the state standpoint. It doesn't mean anything.
I'm sorry, Your Honor, I'm not sure I understand the question.
Well, Article 5, Section 14 says funding the clerk's office through filing fees. In CRISP, basically, Supreme Court said, well, money's fungible, you can go back and forth. What I'm trying to understand from the state's position is that the state's position at this point that the legislature can do whatever they want, or does it prohibit the legislature from doing something, or does it require the legislature? Either one. What is the meaning of Article 5, Section 14?
So our position, Your Honor, is that, as pertains to this case, Article 5, Section 14 leaves to the legislature the question of the funding for the courts. That funding must be adequate and appropriate through the filing fees, but the question of adequacy is reserved to the legislature. And we think this case, in that sense—
Is the legislature in a better position to know what's adequate for the courts versus the court?
I think the answer, Your Honor, is that the question of adequacy, just as in the education context, is not a judicially manageable standard that the courts can apply, because it entails subjective evaluation of spending determinations and relative spending priorities. And
We have a couple cases like Rhodes versus Palm Beach County in the 10th Circuit where the courts have basically said there is not sufficient funding here. And therefore, legislature, you need to do something. Why don't those cases indicate that unlike the educational thing, we're going to step in if due process is concerned, if access to courts is broken, that we're going to actually step in here? So doesn't that kind of subvert your argument a little bit?
So we don't think so, Your Honor. So I think at the end of the day, Ms. Forman's argument that this case is different because it involves the judicial branch rather than the education context, and therefore, entails these additional separation of powers concerns, I think that argument fails for two reasons. First, the specific statutes at issue here only allow the diversion of funds away from the clerk's office to the state court system generally. So all of the funding must stay within the court system and therefore within the judicial branch. Second, Your Honor, the argument that a non-justiciable question becomes justiciable because it affects specifically a constitutional office like Ms. Forman's has been foreclosed by the 10th Circuit Public Defender's case that Your Honor mentioned. So there, the court was willing to acknowledge and assume that what it called severe problems caused by woeful underfunding in the public defender's office, which of course is a constitutional office that, like Ms. Forman's, is within the judiciary and assists the courts in their primary functions, but the court nevertheless held that it could not declare the adequacy of funding there.
Well, I know you're not going to concede this, but could this court step in if we find that there's a willful failure to provide funds that the clerk can't operate? I mean, if the cases are not getting to the judges because the clerks don't have enough funds, can't the court step in at that point?
So, Your Honor, candidly, I don't know exactly how the political question doctrine might apply in a much more extreme case, and I would leave open the possibility that, yeah, there could be an exception in a much more extreme case, but I think—
well, in the education case, as I understand it, there is no exception. You guys stay out of it.
I think that's right.
What I'm saying here is this not different because at some point, don't the courts have to step in if due process concerns arise?
Well, so I'm not sure.
Or access to courts.
Access to courts, perhaps. So I think an access to courts claim might be a different scenario, and we don't have that here. Ms. Forman hasn't brought an access to courts claim, nor has anyone else. That might pose different issues. At the end of the day, we think that the question of what might happen under the political question doctrine vis-a-vis the courts, the funding for the courts specifically, though,
so doesn't it come down to, and I'm sorry for interrupting, that the bottom line here is you're saying there's a lack of proof that there was a denial of access to courts?
I think there's, Your Honor, both.
I'm sorry.
Okay.
How would someone go about proving what evidence would have to be presented to show? I understand your argument about the performance standards. You know, they set those performance standards, that's not the same as constitutional underfunding. But what evidence would have to be presented? And I know I'm asking you to speculate, to demonstrate constitutional underfunding.
So, Your Honor, candidly, I don't know. Because that question hasn't been presented by this case, that's the kind of question I'd have to consult with my clients and my superiors about, and I'd be hesitant to address it for the first time at argument before the court. But I would say that, you know, as Your Honor's indicated, that's not this case, because what we have here is not mere failure evidence. It's that the overall allegation in the case is merely that there are cases being docketed too slowly. So we're not looking at anything here even approaching a complete failure of the courts or even the clerk's core functions. Second, I think if the court is simply looking to figure out what exactly kind of lines might we draw in the context of underfunding for the judiciary, I would go back to the 10th Circuit Public Defender case, which, again, recognized severe problems and woeful underfunding, but nevertheless found that the court could not do anything about the adequacy issue.
What is the nature of the claim as it now stands? As I understand, I read the complaint, and the complaint is all about these statutes are unconstitutional. As a result, we can't do our job. The Chris V. Irvin case addressed that largely, and the trial court upheld all the statutes, as she said that they were constitutional. But it seems like this case has morphed into something different, where the target is now on legislative calculations and allocations that isn't in the complaint. And you raised a standing argument, and I'm just wondering, where do I look to find what is the nature of the claim as it now stands? Because it seems to be very different than what it's in the
Certainly,
complaint.
I'm happy to address that, Your Honor. So, as Your Honor indicated, the trial court absolutely did some things that had very little to do with Ms. Forman's complaint. The trial court specifically enjoined the diversion statutes that Ms. Forman challenges, but it did so based not on the challenge Ms. Forman brought concerning the diversion statutes in Article 5, Section 14, but instead based on problems that the court sua sponte identified with respect to the statutes governing the budget and appropriations processes affecting the clerks of courts. And at footnote 4 of her answer brief, Ms. Forman confirms that she did not challenge the budget process. So we think those issues.
Yeah, I don't think they want to challenge the budget process and the revenue estimating, because it's the process that clerks put in place to protect themselves. So I don't think they want to challenge that.
So,
But that's what's left in this case, right? This is all about the CCOC and how they calculate and how they allocate money. If they allocated more, then they would say, great, we're going.
So, Your Honor, we think respectfully that those issues are not in the case at all. We think that those issues, because the court adjudicated those issues, which were never properly before the court, they serve as an independent basis for vacating the injunction. But I think first we have to discuss whether the court ever had jurisdiction in the first place, which turns on the claim that Ms. Forman actually brought, which is simply the Article 5, Section 14 challenge to the diversion statutes.
Okay, so I understand where we are now, and help me if I'm wrong, and both sides can address this. The only issue that I'm really looking at here, right, and, you know, cutting through all this about revenue estimating and everything else, the only issue is whether the clerk's office at this point is constitutionally underfunded and therefore filing fees have to remain with the clerk. I mean, that's kind of where we are, as I understand it. That it's not the statute that they're challenging, it's the statute as applied. Because we're underfunded, those funds cannot be diverted from the clerk's office.
That's correct, Your
I
Honor.
mean, that's kind of what this case is all about.
That's correct, Your Honor. And Ms. Forman, as Ms. Forman concedes in her answer brief, that is the only claim that she brought. And as for the reasons we've discussed, we believe that there's no reason why there's an exception here for the political question doctrine. Ms. Forman's primary argument, aside from the fact that this affects the judiciary, which Your Honor and I discussed, is that we have manageable standards here, unlike the education context, because we have the CCOC performance metrics. And I think that this court and the Florida Supreme Court rejected a materially identical argument in the Citizens for Strong Schools case.
Okay, Judge Osterhouse, and I kind of cut him off, and I'm sorry, apologize, but was kind of getting into, okay, once we establish what the case is about, would you address the standing issue? You know, if you agree with me what this case is about, underfunding.
So, Your Honor, I think our position is that that both standing and political question or jurisdictional issues that the court can decide in whatever order it prefers, but must decide both before it gets to the merits. And we do think this claim the claim that Ms. Forman brought lacks jurisdiction both on the standing grounds and under the political question.
Well, what if I agree with you that the claim she brought, well, maybe I don't agree with you. I think the claim that she brought, it seems to me like there's basically standing there if the legislature takes all the money and doesn't give any back, and, that they're standing to challenge that under some of the existing case law. I just don't see that as being the claim anymore. It seems like now we're into the citizens type where the claim has now morphed from challenging statutes that I can't do my job because of these statutes to we're not getting enough money, which looks much more like citizens.
So Your Honor, first I think if this court were to hold that Ms. Forman has standing to challenge the diversion statutes, we would still respectfully ask the court to reverse and remand with instructions to dismiss for lack of jurisdiction, because the only question she presented below is a non-justiciable political question. That being said, to address Your Honor's specific point about sort of the morphing of the claim throughout the trial court, I don't think we can say that the claim morphed per se. I think rather we have the claim, Ms. Forman is stuck with the claim that she brought, and we must address whether that claim is justiciable.
So you don't think she lost the claim that she brought? Because as I read what the trial judge said, she said that these statutes are constitutional. And Chris V. Irvin tells me these statutes, the claim that they brought was a Chris V. Irvin was, Judge, these statutes are unconstitutional, and she said, no, they're not.
So to be clear, Your Honor, I think that on the merits, Ms. Forman lost the claim that she brought. I think that before we can get to any of the other issues, including the validity of the injunction, which we believe should be vacated for the reasons I've discussed and the reasons discussed in our brief, we have to discuss jurisdiction. And that turns on ultimately the question that she did bring in the first place, regardless of its disposition on the merits. And let's actually like to discuss the merits very briefly, Your Honors. So should the court disagree with our position on the justiciability issues, we would ask the court to reverse on the merits, and I'd particularly like to address briefly the causation issue that we've raised, and I'd like to focus on the effect on that issue of the court's recent decision in Citizens for Strong Schools. The only evidence of causation that Ms. Forman identifies in her answer brief is the performance metrics themselves and witness statements that problems were caused by insufficient funding. That doesn't distinguish between possible causes of underfunding. And in Citizens for Strong Schools, the court rejected an inadequate funding challenge on causation grounds based on almost identical evidence. It was student performance metrics and then what the court characterized as arguments about the need for more funding. If the court has no questions, I'll reserve myself.
May it please the court, my name is Melanie Lightman. I represent Brenda Forman, and with me at the table is Mark Heron. From the outset, the state has endeavored to cast this case in a light in which it simply does not exist. This is not a case in which Clerk Forman has asked the lower court to make
Can you kind of pull the microphone toward you a little bit?
Yes, to make an appropriations determination or to invade the province of the legislature. This is not a non-justiciable political question. This is not a case in which Clerk Forman is attempting to shirk her duties or is approaching this challenge from a defensive posture. This is a simple case in which she has requested that the lower court review a set of statutes and determine whether they, in their application, reach an unconstitutional result. The court correctly found that they do. As the court was discussing earlier, Article 5, Section 14 authorizes the creation of the filing fees, which are essentially the sole and exclusive.
Would you agree that the trial court's order here kind of clouded the issue?
Yes, Your Honor, I would. There was a little bit more in the trial court's judgment than was raised by Clerk Forman, but I do not believe that that undermines the core findings that were in there.
Well, help me, because I'm trying to get both of you to try to understand what the issue is or what was actually being tried here. Is it your position that the statutes were unconstitutionally applied when money was diverted from the filing fees, were diverted from the clerk's office, which they can be, according to Chris. But at the point where it resulted in underfunding the court system, that was an not court system, the clerk's office, that was an unconstitutional application.
So, Your Honor, it is the clerk's position that the statutes in their application essentially effectuate an inversion of the prioritization in Article 5, Section 14, which was created for the purpose of clerk funding with the permission essentially to...
You're getting me confused now. I'm trying to get you to the issue. I understand you're making arguments, but I'm trying to get to the issue. You're making arguments on it, but what I'm trying to get to the issue here is I understand your argument, and I'm cutting it down to the bare bones because I'm trying to figure out what the issue is here, that these statutes are being unconstitutionally as applied when the diversion results, and I'm not saying you proved that, but when the diversion results in the clerk's office being constitutionally underfunded.
Yes, Your Honor, that's the crux of the argument, that the diversions have become so substantial and that there is an absence in the statutes for any sort of consideration of clerk need. And that's where I was talking about the sort of the inversion of prioritization, that Article 5, Section 14 authorizes the creation of these statutes for the purpose of funding the clerk's office and permits the diversion of excess revenues. But at this point, it's kind of evolved into this system where the diversions are what take priority per the statutes because there are fixed amounts, and regardless of how much comes into the clerk's office, the same amount gets diverted to the general revenue fund or the other trust funds.
If we agree with you that you proved it, what remedy can the court fashion based on your proof?
Yes, Your Honor, and it is our position that the injunction was properly entered, that the trial court went through the analysis, and while I will agree that there was a little bit of muddying of the waters with her digging into the CCOC and REC process, which is not what we're challenging here, but that the injunction is the remedy that must flow from a finding of unconstitutional as applied.
And what would the injunction say if we agree with you? What should the injunction say?
The injunction enjoins the further diversion of the statutes because of the unconstitutional application to the clerk's office. So it's not the clerk's position that necessarily that she's entitled to 100% of the filing fees, but because the applications of the statutes reaches an unconstitutional result, it's unworkable and they cannot continue to operate in that effect with respect to Clerk Forman.
Okay. Let's look at the standing issue first.
Yes, Your Honor.
Seems to me the first prong of standing doesn't apply. So the two that we're maybe looking at is legal expenditures.
Yes, the public
or
funds
precluding her
exception.
from doing her duties, basically.
Yes.
Could you address those two?
Yes, absolutely. The public funds exception would apply in this case to Clerk Forman. The state cites the Echeverry case in an effort to narrow the public funds exception. And while there is commentary about the public funds exception in Echeverry, it's pure dicta. The Florida Supreme Court specifically declined to address the public funds exception arguments that were raised in Echeverry. If this court takes a closer look at the substantive analysis.
Isn't what you're really arguing about appropriations, though, that I was not appropriated sufficient money? I mean, isn't that the bottom line?
No, Your Honor, I would disagree that this is a case about appropriations. This is a case where the Constitution creates this mechanism for clerk funding, and the statutes in their operation do not comport with the constitutional language and the constitutional intent.
But the statutes would comport if they would have sent back $2 million more. You've asked for $2 million more a year or something in that nature. Is that correct?
Well, I don't believe that there's evidence in the record specifically as to what the clerk would like or where the line should be drawn, and that's not really the exercise that we asked Judge Giebers to engage in or that we're asking this court to engage in. I think that setting a specific amount or asking the court.
Did you have to establish that you were underfunded?
Yes.
And so what did you establish then if you didn't establish a figure?
We established the underfunding through the performance measures and other issues that the clerk's office was facing, which are tied to the budget deficiencies.
Are those external performance measures or internal or what?
Those were the performance measures. They were set by the CCOC at the direction of the legislature. And the state in its briefing and in its oral argument today attacks these performance measures as insufficient. And it's our position that that's a little bit disingenuous. These were created at the direction of the legislature for the purpose of measuring clerk performance. So if there was some concern that they were not adequately designed and not effectively
Were they there for
measured.
help for the appropriations process or to establish a minimum constitutional level of funding?
Pardon me, I missed the first part of your question.
These performance standards,
Yes.
when they were established for the purpose of helping with the appropriations process or determining constitutionality of the funding levels?
Honestly, I'm not sure of the intent of the creation of the performance measures initially, but they are these standards that are in place to gauge clerk performance. And if they're not sufficiently gauging clerk performance, or if they're too strict, as the state may have suggested, then the legislature is certainly welcome to address that. That's certainly within its purview.
Well, they point out something very valid here. Couldn't failure to meet performance standards based on inefficiency of the clerks, individual clerks? I mean, one clerk with 1/10 the funding might be able to do something a lot more than another clerk can do.
Yes, Your Honor, but there is no evidence in the record presented by the state. I suppose there are a number
Whose
of.
burden is it?
It is our burden, and we presented evidence tying the performance measure deficiencies and other performance deficiencies to the funding. The state did not present any evidence controverting that, and that's one of the main distinctions with the school funding cases that counsel was talking about. In the school funding cases, among many other market distinctions, there was a very robust record presented by the state to controvert the evidence that the petitioners put on. And by the time it even got to the Supreme Court oral argument and the Supreme Court opinion, most of the evidence that the petitioners were relying upon was stale at that point. The comments about the robust evidentiary record refuting the petitioner's claims is interwoven throughout the entire Supreme Court opinion. That was a big issue that is very, very different than what we have here. If you would like me to continue, I can go over some other distinctions between the school funding cases. There are measurable standards, as we have
Okay,
discussed.
well, you never discussed the last problem
Okay.
of the standing case.
Yes, yes. So the public funds exception would apply. This is the collection and expenditure of public funds, which the cases provide that allows for the public funds exception. And then the final carve out, so to speak, is that Clerk Forman is prevented from performing her duties. At this point, there is no duty or set of duties that Clerk Forman has identified that she is trying to avoid. She would like to fully perform and effectively and efficiently perform.
Okay, if we adopt your standing problem here, does that mean that every public official in the state, if they think they're underfunded, has standing to sue
No, Your Honor, I don't necessarily.
for constitutional underfunding?
I don't necessarily think that's the case. I think that the specific language in Article 5, Section 14 is what does set this case aside and make it a little bit unique, that this the filing fee and service charge structure was created for the sole and exclusive purpose of funding the clerk's office. This is the only source of funding absent, the only supplementation that the Constitution envisions is if revenue falls short because of constitutional mandates preclude the imposition of filing fees, for example, in indigency. I don't know of any other constitutional officer which is funded in that same scheme, and I would assert that the constitutional language in Article 5, Section 14B is what makes this case a little bit unique, and it wouldn't necessarily open the floodgates to allow any constitutional officer or any public official generally to raise constitutional challenges due to underfunding. It's unique to this set of statutes, the application of these set of statutes, and the result that flows therefrom.
Is this the only circumstance where there's constitutional underfunding, where Article 5, Section 14 would constrain the legislature in their appropriation decision?
I'm not sure. There wasn't any testimony in the record regarding other. Are you talking about other officers?
I'm just trying to figure out
Or other
the
clerks.
scope of what Article 5, Section 14, how my first question to the other side. What does it require and what does it prohibit?
Yes, okay, yes, Your Honor, now I understand your question. The Article 5, Section 14 permits and requires the establishment of adequate and appropriate filing fees, and I would like to underscore the adequate and appropriate filing fees are not, the adequacy of the filing fees themselves is not what's at issue here. And it.
But that's what the Constitution requires.
Yes.
Okay.
Yes, but we're not challenging, we're not saying that the civil filing fee for new cases is not adequate. That's not the challenge that's being levied. So it directs and requires the creation of these filing fees. And it also specifies that this is the only source, absent that tiny little exception, which is, there's no evidence and there was no testimony regarding the impact that makes, but it is not, that's not the issue that is here. So,
I'm going to switch,
yes.
because I wanted to ask one question before I forgot it. There is a process that if an individual clerk's office feels they're underfunded, they can go to this commission and ask for more funds. Was that done in this case?
So if I can back up a little bit, the process is, it's as Judge Evers stated in her order, this is like trying to untangle a plate of spaghetti. There are kind of two tiers of diversions, if you will, and I'll get to your question, I promise.
Okay.
There are kind of two tiers of diversions, if you will, where there are the diversions that go to the general revenue fund and the similar funds that are a set and a set amount per each filing fee. And then there are diversions that go to the Clerk of Court Trust Fund. The Clerk of Court Trust Fund is the trust fund that's available for the clerk to make supplemental requests, but all of that is tied to whether or not the clerks are actually bringing in excess of the cap that is set by the REC at the beginning of the fiscal year. So I don't know if I'm
Okay, so
getting
they
this
can
right.
only
So that
request money up to,
the trust fund.
from the trust fund, but you're saying there's a cap of what they can request? They can
Yes,
only
up to
request
what
the original appropriation was.
the original estimate was from the REC, and that's adjusted throughout the year, and the record evidence reflects that it has been adjusted downward throughout the year. So the clerks don't necessarily get to say, okay, this is the budget that I was assigned. I don't think I can operate in this budget. I'm going to go to the Clerk of Court Trust Fund and ask for more money. What happens with that Clerk of Court Trust Fund is when the clerk is assigned a budget, the revenues are not meeting that, and they can go and ask for supplemental funding because what they're bringing in is not bringing them up to that level.
Okay, and that goes back to another question I had earlier. Does this only go to the original appropriation? So you're saying the original appropriation resulted in constitutional underfunding?
The application of the statutes results in this system, this budget system where this cap is set based on the estimate of the revenue that's going to come in, not based on clerk needs. So there is no connection.
Well, that's called budgeting.
Pardon me?
I kind of laughed when I read the trial court's order saying, well, you can't budget based on revenue estimates. That's called budgeting. I mean, so, this whole idea that, part of the budget process is not based on the money you're going to be taking in.
Well, but
That's a non-starter for me.
Well, so the distinction I would make is it's not necessarily based on the money that's coming in. It's based on the money that's available after these diversions have been made to non-clerk uses. So this entire pot of money
So
that's coming
basically
in.
what the legislature decided to appropriate for the clerks.
Well, what what basically
Because you
what's.
wouldn't have a complaint if the legislature appropriated all this other supplemental funding, would you?
Well, it wouldn't be unconstitutionally underfunded at that point. But the problem, and I highlighted this earlier, is not that the legislature is diverting or that the legislature that has the power to appropriate a specific amount. It's that these statutes operate in such a manner as to basically set the diversions as the priority for this Article 5, Section 14 filing fees rather than the clerk's office. And the clerk, as a subset of the judicial branch, is entitled to be funded in a constitutional manner. And it's our position that the statutes operate contrary to the intent of Article 5, Section 14.
And, you know, I asked the other side, after Crest, does Article 5, Section 14 mean anything? Because what bottom line comes down to, you have to show unconstitutional funding, which can also be part of the legislative appropriation process. Because they could fund it from other, money's fungible, as the Supreme Court said in Crest. So
Well,
does not just this come down to, and I'm sorry, not so much on Article 5, Section 14, but the clerks aren't getting enough money from the legislature.
Well, so the Chris v. Irvin is not dispositive, and it's the challenge that was brought in that case is very distinct from the challenge that was brought here, and the arguments
understand
related to
the tax
fungibility.
argument.
Yes, and the arguments related.
But they also, maybe dicta, but there was some very strong dicta about money being fungible and appropriations can go in, and the legislature does appropriate money for the court system. So I'm
Yes,
really
sure.
trying to understand at this point in my head, and it may be a theoretical exercise, but whether there's any meaning to Article 5, Section 14 whatsoever at this point, except for the filing fees have to be adequate to fund the court system.
Well, if I may go back to Chris v. Irvin, the fungibility discussions were relating to tracing the actual specific dollars that were diverted and whether or not they were going to court-related functions, not to addressing the money. Because the way this system works is the clerk collects everything and then sends the diversions back up to the state and retains portions. So it's, you know, we're not asking the state to trace every single dollar like the petitioners were in Chris v. Irvin, to trace every single dollar that goes back up to the state to guarantee that they are going to the stated purposes in the Constitution. And Chris v. Irvin was raised as a as-applied and a facial challenge, and this is just an as-applied challenge. The prevailing issues were the fungibility of money with respect to those diversions, and the challenge was levied at the existence of the diversions themselves, not the size of the diversions or the lack of consideration for clerk need. Additionally, you know, while there were arguments and the court did address Article 5, Section 14, those were not the central arguments. They were basically an afterthought. The Supreme Court addressing it was brief and perfunctory. They weren't central issues, and the Solicitor General in her opening comments to the Supreme Court in oral argument made it clear that this case is only, this is a quote, only about the deposit of a portion of the filing fees into general revenue. And that's just not what we have here. With respect to the merits, as I stated earlier, the state presented no evidence to refute what the clerk has presented, only conducted limited cross-examination, and even conceded in its briefing that the plaintiff's office, the petitioner has experienced some difficulties that additional funding might ameliorate, and the finding regarding underfunding has factual support. It is our position that the court correctly found that Clerk Forman has standing, that the lower court had jurisdiction, that the clerk established causation, and that the injunction was properly entered. We ask that this court affirm. Thank you.
Thank you.
Your Honors, I'd like to briefly address, I think, two key questions posed by Judge Wolf. First, Your Honor asked about the purpose of the CCOC metrics. And I think, Your Honor, the answer is that nothing in the statute setting up and calling for those metrics indicates that the legislature intended them to serve as any kind of implementation of the adequacy standard. In particular, I think that's clear because if a clerk fails one of the metrics, the statute simply provides that the CCOC must tell the legislature, but there's no actual consequence for that. Instead, it simply provides information that the legislature can act upon consistent with Section 28.352C, which directs the CCOC to provide recommendations to the legislature regarding adequate funding. And I think that provision alone shows that the legislature intended to retain its independent discretion as to funding. And also for the reasons discussed by the plurality opinion in Citizens for Strong Schools, we believe that in any event, we cannot conflate constitutional minima with statutory standards. I'd also like to briefly address the standing questions that Your Honor asked. So, Forman challenges statutes that affect her duties, specifically the duty to remit portions of filing fees that she collects to various state trusts. She therefore lacks standing because public officials are required to presume that the statutes affecting their duties are valid and therefore lack standing to initiate litigation for the purpose of determining otherwise. And Your Honor asked about the public funds exception. The public funds exception, both the Florida Supreme Court and this court have characterized as a narrow exception, and in the Islands case, this court limited that exception to statutes that require the expenditure of public funds, and here we don't have a statute like that that's being challenged. Instead, what we have is 9 statutes that serve as what the Florida Supreme Court described in Christ versus Irvin as accounting mechanisms. And I think the distinction between a statute that requires an expenditure and an accounting mechanism becomes clear when we look to the purpose underlying the public funds exception. Specifically, the purpose is to protect the public fisc. When we have an invalid statute directing the expenditure of public funds, the public fisc is threatened because funds are depleted. When the funds are pursuant to the statutes we have here, merely kept within the Treasury, there's no such problem. I'd also like to address the exception invoked by Ms. Forman concerning, this is from the Reed and Gronmeyer cases and their progeny. It's for officials that were bringing a challenge because they seek to comply with their duties and are prevented from others by doing so. In no case applying that exception has ever done so when a plaintiff was challenging a statute. And in particular, the Reed and Gronmeyer cases actually both emphasize that the general rule does not apply because the plaintiff there, or I'm sorry, the public official there was not challenging a statute. So
if the statute said keep $100, send the rest to the legislature and operate on $100, even though effectively we could all agree they couldn't do their job, this standing exception wouldn't apply to them being prevented from doing their job?
I think the answer, Your Honor, is that I think she would not have standing, but that's not because the idea is that if we had 2 statutes that tell an official, you know, one says to do A and the other says do not do A, we have a direct conflict. We might have a different scenario here. What Ms. Forman is alleging, and the substance of Your Honor's question, is these statutes, by taking away funding, make her other duties more difficult to perform. But that's true of virtually every statute that affects the duties of a public official. So if we were to have the exception broadened
Wait a
that way.
second, though. You say make it more difficult. I think what they're saying is that they were constitutionally underfunded and therefore could not perform their duties that they are required to perform under the Constitution.
I think that's true, Your Honor, but it's a matter of degree. Their allegation is not, for example, that they've been underfunded to the point where they cannot docket cases. The specific performance metrics
So
that they
doesn't
identify.
degree go to proof? I mean,
I'm sorry,
rather
Your
than
Honor?
standing? If they're alleging that they're constitutionally underfunded to the extent that they cannot perform their duties, doesn't that get them past standing? And at that point, doesn't it become a question of whether they actually prove their case or not?
I think the answer is no, Your Honor, because I don't think the allegations fall within any of the exceptions. But if the court disagrees, we nevertheless think the court should reverse and remand with instructions to dismiss on political question. If there are no further questions, thank you.
Thank you. You need a break? You need a break? Okay. Thank you for excellent oral argument. The next